I was asked by the kind gentleman who was here 2 weeks ago to set the sound system to a fairly high volume so that not only would my voice be heard in the back rows, which is not required any longer because the number of listeners have really reduced themselves, but also to make sure that the recording on the internet comes out nicely. And yeah, since we're now back after a break of 2 weeks, really, because I had to cancel last week's lecture, I would like to let you know that I will, of course, give you a substitute lecture. I have to fulfill my contract in that I have to do 12 lectures at least per semester. And of course, before we have the end of term test, before we have the first session of the test, at the end of this semester, in the very last week of June, there will be a substitute lecture to make up for lost time from last week. It will not be Monday morning though, because Monday morning is the regular lecture time, and during exam week, that is to say the week starting on the 2nd of May, I understand that this hall plus the other hall, number 5, where I can record the lecture, will be taken, will be used for exams. So I can't really give you a substitute lecture during that week and not at the same time as the lecture. So I will have to find an open slot, probably Tuesday morning, and you will of course be welcome to be here. If you can't make it because you have someplace else to go to, because it collides with one of your regular courses, don't worry, you can read up on it and listen to it on the internet. I keep repeating that on Fronter you will find the RSS feed. Let me just show you what it's supposed to look like and how you access it. Basically, unless you have any other link to use, you can access Fronter through the website of the center. And via the eGate. Well, I don't really have to go through the eGate, in fact. I do. Okay. You will find that this is the start page, depending on the other courses that you have signed up for. Right, and now here, this is where you find the important messages from myself, and this is where you find the RSS feeds. Okay, 3 different types of definitions: very good quality, medium quality, and low quality. And so you just click on Startseite and then you get there if you want to listen to a lecture once again. As for the written material, you find that on the same page. You find it in resources. And as you can see here, this is the list of words, which replaces any lecture notes that you can buy. You cannot buy any lecture notes for this semester because it was actually developed from scratch, and I never gave it to the man at the Dolmetsch shop for copying. Okay? And this is a text. The text that we're dealing with. It's basically a copy from the internet. That you can also, or ought to be able to access if you do this. No, you can't. Okay. So, I'm taking this back. You cannot access it by clicking on the link here. You might have to put it in by itself. Right. So, okay. I would like to make a few more points on the procedure followed in this lecture. I received a few inquiries about how to go about it, how to learn for the exam, and etc., etc. And it might have been confusing to you if you come to this lecture for the very first time. Now, there are texts on the internet, there are texts that I show you during the lecture and links that I recommend. We will not read these complete texts during the lecture. It's not the purpose. The purpose is to show you where you can find additional information. So my recommendation is take some time. This is a course that you will have to do some studying on your own. Take your time to follow the links and do a bit of reading and do a bit of research. Look up words on your own. If you're in doubt about the meaning, you're perfectly allowed to send me an email. I might not respond immediately, but I might take the questions to class with me. I might bring them here and answer them in the lecture, or I might answer them directly, okay? The texts are important because they give you the context for the words that I mention, the vocabulary that I'm trying to impose on you as being important if you ever want to understand and work in the field of law and economics, okay? Both fields are so vast that I can only, take a few selected fields. I can only give you a few glimpses, and I will always say, and this leads there, and this leads there. But we can't go there right now, okay? You have to accept that, I'm afraid, because the field is so vast and so detailed. It goes for the other semesters too, because humanities is a vast field, technology is a vast field, and so is natural science and medicine too. In fact, you have to imagine that originally what is called Fachkommunikation, technical communication now, used to be 8 semesters. 8. 4 devoted to law and economics, and 4 devoted to humanities, natural science, medicine, and technology separately. And you were supposed to do all of them to really get the full picture. And even then, you didn't have the full picture, but you had a sound basic vocabulary. Now, this whole thing has been cut down to 4 semesters in total. And as far as I know, you don't even have to take all the 4 semesters. So what you get is a tiny glimpse, really, and you will have to do a lot of work on your own. What I want to give you is the very basic vocabulary, and what I want to give you is an idea of where to look for more, okay? It won't work without you studying what we do in class, plus some extra things, okay? You will know from the description of the course that basic vocabulary, basic skills in grammar, and so on and so forth, in both German and English, are indispensable. You will not be able to do without it. if you want to pass the written test. And unfortunately, so far I've found that the problem is very often not so much the words that are lacking, but the grammar that is lacking, and the ability to express a thought clearly. But that's not what I'm here to teach you. That's what you do in your TBK lessons and in other lessons, okay? So you ought to have a sound idea of how to write a text before you take the exam, because I'm not going to teach you how to write the text. For the exam, you will have to do 2 summaries. I think I talked about that in the first lecture. I'm repeating it here because I've been asked for sample tests. I haven't uploaded a sample test for law and economics yet, but I will do so. Suffice it to say that it's a word test. That is to say, I want to test your vocabulary. Of course, I can't do that if you bring dictionaries with you and if you work on your computer. So the final exam for this lecture will be no aids whatsoever. It will just be paper and pen, okay? No internet, no nothing. Because, as I said, I will need to test your ability to remember words, and I will test your ability to use words in context, because you will have to write 2 summaries, one in English, one in German. And it will also be a tiny piece that you need to translate, where I don't want, a rough summary, but something that is as close as possible to the original, only in the other language, and of course, translated properly. What can you do to get more familiar with things, in addition to what you hear in class, what you hear in the lecture? Good daily papers usually have supplements on law, for example, on economics. So you might just want to read those and maybe jot down a few words or contexts you don't quite understand and do a little reading on those, okay? If you haven't had any training like from a commercial college or something like that, you might find it hard to understand certain economic contexts, yeah. And I suppose none of us, or just very, very few of us, will have legal training or do legal studies in parallel. So you will need to kind of go beyond the layman's or the laywoman's knowledge by doing some reading on your own. And you can do that, as I said, by reading the legal supplements in papers, by reading the economic pages in quality papers such as, I don't know, Die Presse, der Standard, and of course Die Zeit and other German papers. Weekend editions might come in useful here, okay? And as I keep saying in all my classes, even read the sports pages, though you might not be interested in sports, okay? Do it, simply do it. And do the same thing for all your other languages. If you want to be a transcultural expert, there's no way around it. Another important thing is your tests. Once you can see your grade, your mark on the internet, that's that. And you're happy with that, or maybe not so happy, but hardly ever does anybody come to pick up his or her test. Now, we are prohibited from leaving tests in public places for various reasons, because of data protection. Nobody's supposed to know which grade you got, and also because tests were stolen in the past. For whatever reason, people wanted to know what somebody who got an A, wrote in the test, maybe for the sake of comparison or whatever. So you need to come to me during my consultation hours, that is to say between 1 and 2 o'clock, Monday, at room N406 in this building, to pick up the test, and you have to sign for it. Okay? But it's worthwhile because normally I take a lot of time when it comes to correcting the tests. And you can get a lot of feedback by just looking at what you did wrong. I mean, if you got an A, chances are that you didn't do a lot of things wrong. But if you got maybe a 3, a C, you might learn from it. So come and pick up your tests, okay? Even though it's a complicated and bureaucratic procedure, and it used to be easier when you were just able to open a pigeonhole or a drawer and get your test. It doesn't work like that any longer, unfortunately. Okay, having said that, let's move on to that famous page I wanted to take you to see whether it still exists, because I was under the impression that it still existed, but maybe it's not. Hamlin, T-O-C-H-T. Let's see. Don't do this to me. Don't say they removed it from the internet. No, but if they did, then it's still on the internet in the form of the copy that I drew from it. No, too bad. This text on laws and the legal system was actually an introductory course for people starting as law students. And I thought it was extremely useful. But obviously, it's been removed. Sorry to say that. So we have to rely on my own copy, which fortunately we still have. Got it on my USB stick anyway. Here we are. Okay, now. So unfortunately, forget about the link to the University of Leeds and refer to the text as copied. It is a useful source, although in the final analysis it ends with civil law, with the subject matter of law systems, and I don't think that it provides it does not provide for many of these links any longer, because obviously they've ceased to exist. So the Ombudsman and so on and so forth are no longer in place. As far as I remember, we quickly scanned through this first part of the text that dealt with how law, the concept of law, is approached on the two sides of, I shouldn't say the Atlantic, but the Channel, really, the Channel and the Atlantic. So I tried to make a little distinction between case law and statutory law in the first lecture. The text also provides for a few links, which will probably not work any longer, but could be followed up if you put them into Google, when it comes to the structure of the judicial system and the legal system in the UK. The UK, as you know, being called the United Kingdom of Great Britain and Northern Ireland in its actual official designation, which points out that there might be differences between the individual parts. And I would urge you, unless you do that in Gerhard Frank's lecture, which I doubt that he will go into so much detail, I would urge you to actually have a look at the judicial system, the legal system in England and Wales. Now, I've been using two words here, legal system and judicial system, which are not quite the same. Legal system, Rechtssystem, being somewhat bigger and more comprehensive than judicial system. Judicial system meaning die Justiz, okay? So that is to say, the system of courts, not just the system of courts and the instances involved, die Instanzen, that is to say, the structure or the tiers in the court system. Also der Stufenbau des Justizsystems, which is something different from the legal system. Rechtssystem is much more comprehensive, as I said. So, you might check a bit on the legal system of England and Wales, Northern Ireland and Scotland. And with this in mind, I will just move to the internet for a brief moment. Just to give you an example. Wikipedia is always a good source if you wish to learn more. And here you would find the various courts in Northern Ireland, for example. The reason why I'm skipping this here is because there is something else which is not, the processed website on Wikipedia, but an original website. And if I have a choice, I might do the first reading for very basic information on Wikipedia, but I might then look for the original websites, just to give you a feel for different sources of information. All the courts in the UK, Northern Ireland, as well as in the Republic of Ireland, have their own courts and tribunals service. These are very useful websites directed at the consumer, at people who take recourse to justice or who take recourse to the courts, also Menschen, die sich an die Gerichte wenden. Okay? And it might really be useful to look at for example, the various types of tribunals. The various services that they offer. Okay. And try to read up a bit on what they do. Okay, as you can see, it's back again. It's just a different name. Very good. All right, here we are back again, and you might want to remember this link, because it will give you a nice overview of the legal systems and of the court systems. Criminal cases are something that I did not deal with when I first did this semester, but we might just as well have a look at it, because the content, of course, of my lecture can vary according to my whims, maybe. And we might just as well, now we're here, have a look at it. This explains to you that criminal cases, Strafverfahren, which you might also find as under the name criminal proceedings, as a word that exists in both the plural and the singular, and even when in the plural might refer to just one proceeding. That might be a little confusing at times. Sometimes people say, in this proceeding we have found that, and sometimes people say, in these proceedings we have found that, and they still mean just one case. It's a bit confusing, as I said, but it is obviously English usage. Yeah. And this tells you that more serious criminal cases are tried on the basis of a document called the indictment. What you can see here is the proof of the fact that pronunciation in English is sometimes a bit tricky, because the spelling does not really lead you to believe that it's pronounced indictment, but it is. Okay? So a person is indicted, and the paper that contains the charges against this person, the criminal charges, is called the indictment. Die Anklageschrift, das ist die Basis der Anklage gegen eine Person oder der Anklage einer Person. Und es enthält die Anschuldigungen, the charges, die Delikte, die dieser Person auf Deutsch zur Last gelegt werden. So, whenever you come across this wonderful German phrase, Ihnen wird zur Last gelegt, you are charged with having done this and that. That's the English equivalent. And even in the Austrian system or the German system, you would translate Anklageschrift as indictment. Okay? Sometimes in Austria, and I might be jumping back and forth between two systems now, sometimes in Austria you will come across something called the Strafantrag. Now, what's the difference? To tell you the truth, it is still an indictment in technical terms, in terms of content. The only difference between Anklageschrift and Strafantrag is the court instance at which this happens, or the seriousness of the crime. Because not every offense, not every punishable offense, nicht jede strafbare Handlung is actually a crime, is ein Verbrechen. It could also be a misdemeanor. A misdemeanor being ein Vergehen, which is something of a lesser gravity. Okay? Yes? Oh, Anklageschrift? Yes, die Anklageschrift. Yes? This person is charged with having. You don't need the word indictment here. The word indictment would come up in a situation where a court interpreter is, for example, asked to translate the indictment to the person being charged. Die Gerichtsdolmetscherin oder der Gerichtsdolmetscher wird aufgefordert, die Anklageschrift zu übersetzen. And that would be the indictment. In the actual situation in court, and since I am a court interpreter, I can give you first-hand experience. The situation in court is as follows. You're sitting there as an interpreter, you're sitting next to the judge, that's the Austrian system, and then the judge hands over the indictment, which is, you know, a piece of paper or maybe 10 pages, 20 pages, depending on the number of charges against the person sitting in front of you. And yeah, you're supposed to translate that on site. So you have to find your way through all those paragraphs and sections and do a nice site translation so the person sitting in front of you understands. The whole thing must have been translated before, because normally handing over the indictment is a formal action within the proceeding. So normally the person will be familiar with it. But nevertheless, sometimes judges are very formal in what they do, and they follow the procedures very, very painstakingly, and then they ask you to translate it again so as to make sure that no formal mistake is committed in the proceeding. And the person sitting before you is called the defendant, der Beschuldigte oder die Beschuldigte, before the indictment is read and officially handed over, and afterwards this person is called the accused, der oder die Angeklagte. Unfortunately, judges usually don't really draw that distinction. So it's more of a paper distinction than a real-life distinction. In most cases, they just refer to this person as der oder die Beschuldigte without really using the word Angeklagter or Angeklagte. But actually, that's the distinction that ought to be drawn. Okay, so what we can read here is a nice set of phrases and, of course, information for content. The defendant is indicted on criminal charges specified in the indictment by the prosecutor. In most cases, the prosecution is on behalf of the Crown or the state and is handled by an official agency called the Crown Prosecution Service, which takes the case over from the police, who have already investigated most of the evidence. Now just take out Crown and replace it by Public Prosecution Service or Public Prosecutor Service, and you have a fine translation of the Austrian word Staatsanwaltschaft or the German word Staatsanwaltschaft. In England, of course, since they have a queen, it has to be the Crown Prosecution Service. die Kronanwaltschaft. In Austria, we only have a state where Austria is a republic. The same goes for Germany for all intents and purposes. And here it is called the Public Prosecutor's Service or the Public Prosecution. There are hardly any totally official translations. So you have a certain degree of freedom in that. I hate doing this to you, but I will now jump back and forth, I'm afraid. Okay, now this is actually where you would find most useful information about the Austrian system. Okay? And since all the ministries by now have more or less complete English translations of their websites, yeah. You will find this here. Information on the Austrian justice system and its institutions, including the Ministry of Justice, the courts, the offices of public prosecution, the detention centers, the probation service, and the federal cartel attorney. So they call it the offices of public prosecution officially now, die Staatsanwaltschaften, the detention centers. In Austria, you'd probably refer to it as die Justizanstalten, not just simply Strafanstalten, but Justizanstalten. The probation service. Are you familiar with that from American crime stories, crime series? Die Bewährungshilfe. And the federal cartel attorney is die Kartellanwaltschaft, die Bundeskartellanwaltschaft. Okay. Needless to say, Germany and Switzerland again have their distinct systems, different from the Austrian. And you can even see that in the name, because in Austria it's the Bundesministerium für Justiz, whereas in Germany it's always der, das Bundesministerium der Justiz. In Austria it's also the Bundesministerium für Inneres, so we always have this purpose of für, and in Germany it's always the genitive Bundesministerium des Inneren. Okay. Same thing here. And again, this is where you find the official translations. Sometimes you might not entirely agree with them, but since they're official translations, you might just as well accept them. Sometimes you have to. And as you can see, here's a translation, the Courts of Law in the Federal Republic of Germany, which gives you a nice translated overview of the court system in Germany. And let's do the same thing for Switzerland. So we have covered all the German-speaking countries. Okay, we have a Bundesamt für Justiz there. Which is one of 4 federal offices of the so-called Department of Justice and Police. So the Bundesämter, mind you, are actually subordinate agencies, and the important thing here, the overarching umbrella is the Department of Justice and Police, which is basically a combination of our justice and interior ministries. Okay? So Switzerland has a slightly different system here. Where else would you find justice and police combined in one ministry or department, government department? Yes? No, it's not an authoritarian country. It's the United States. In the United States, you have this strange combination too. In Austria and Germany, and also in the UK, there are 2 distinct ministries or government departments. One is called either of the interior or for the interior in translation. It's called Home Affairs, actually, in the UK. And it's a separate ministry. Yes? I don't know. And the question was for the Vatican. We can Google that. just remember the idea. I would just like to finish my train of thoughts about the United States, okay? So in the United States, we have the Ministry of Justice, which is actually called Department of Justice, DOJ there. And all the federal agencies in charge of crime fighting, of law enforcement, are actually subordinate to the Department of Justice. So it's a combination of home affairs and justice. The local police departments, the local police systems really are again a matter of the individual federal states and of towns, etc., etc. Okay, so the System of Justice and Law Enforcement, also das System der Justiz und der Exekutive, Exekutive im Sinne von Polizei, im weitesten Sinne, is probably most complicated in the United States. And very hard to see through from the point of view of the separation of powers. Also schwierig zu begreifen aus Sicht der Gewaltentrennung oder Gewaltenteilung, aber so ist es. Okay, now let's see. This question for the Vatican came as a bit of a surprise, but why not? Might just as well look at it in an English version. So, obviously, the Vatican has kind of a separation of, or a division of labor, I should call it. A division of labor, Arbeitsteilung with Italy. Ordinary legal matters within Vatican territory are dealt with by a tribunal of first instance, also ein erstinstanzliches Gericht. Criminal cases are tried in Italian courts. And there are 3 tribunals for religious cases. So this is very much something that requires a matter to be one of church law, of ecclesiastic law, rather than civil law or criminal law. Okay? Does that kind of answer your question? Okay. So obviously for civil law matters, tribunal of first instance, criminal cases in Italy, and much of what the courts in the Vatican do are religious cases. But coming back to where we started from. I actually used the word jurisdiction, I think, in the first lecture, and I hope I did not completely confuse you by doing that, because what I thought to point out was that jurisdiction does not necessarily mean Rechtsprechung, always, but also Zuständigkeit. That's really the point I was trying to make. And the last two paragraphs in this text actually refer to the different legal systems, that is to say the different laws applicable in Great Britain and Northern Ireland, that is to say in the three jurisdictions, in England and Wales, in Scotland and in Northern Ireland. Also in den drei Zuständigkeitsbereichen, wo es teilweise unterschiedliche Rechtsformen gibt, beziehungsweise unterschiedliche Gesetze gibt. And the combination of it when it comes to acts of parliament that are valid for all jurisdictions. In the context of the term jurisdiction, you always have to distinguish between two important words, and that is subject matter jurisdiction and local jurisdiction, which in German you find reflected in the word örtliche Zuständigkeit, local jurisdiction, and what's the word now? It's not inhaltliche Zuständigkeit, in fact. Sachliche Zuständigkeit, that's the German word. Subject matter jurisdiction. Sometimes you will come across the word Zuständigkeit in German without actually referring to a court, but for example a ministry. Das fällt in die Zuständigkeit des Innenministeriums. And in that case, it would be safer to use the word remit for Zuständigkeit, so as to keep it nicely apart from the jurisdiction of a court. But sometimes the boundary is blurred, so I wouldn't rely on it all the time. Okay, now coming back to this part, the courts in England and Wales and the criminal cases. So there's the prosecutor, and in the first stage, the decision will be whether there is a case at all, and that's the committal. In Austria and Germany, the stages of the proceedings would be slightly different, yet very, very similar. and the committal would most likely translate as Anklageerhebung, if I'm not totally mistaken. Oops. Yes. Okay. What you've just seen was a very rough method of checking whether a word is correct as I think it should be translated. Of course, there are nicer ways than just typing in one word and the English or German equivalent. But of course, if you have an educated guess of what something could mean, you might just as well try by just simply Googling both words in one text, and you might come up with glossaries or word lists that seem reliable. If you want a slightly more reliable way, you might want to use a legal dictionary. Okay? And here's an example of a legal dictionary that exists in at least the CD-ROM version. It is called Beck-Lex, and the actual authors. The actual author is Clara Dietl. It used to be Dietl Moss Lorenz, but I think the most updated versions are now by Clara Dietl alone. That's spelled D-I-E-T-L. And Beck-Lex is the publisher. Okay. Now, what you find here is, of course, a little more detailed and exact, saying that the committal proceedings would be more of a Vorverfahren. And I quite like that because it's, as I said, more detailed and more precise than what I said earlier. Anklageerhebung is very general, really, and could just as well be indictment as a process, not just as a written piece of paper. So this shows you that a little more research and a little critical reading can help a lot. Now coming back to this, it refers to what is called a prima facie case here. Now this is a special type of Latin word, like so many other Latin words that come up in legal language, not just in German, but also and especially in English. And in fact, sometimes you also find it combined with evidence. And the German word would be Indizien. Okay, so it's what you look at, and at very first sight, it looks like you have a case there, like you have evidence there. So on the basis of this prima facie evidence, the prosecutor and the lower instance magistrate or the pre-trial magistrate will decide on whether there is a case and then prepare the related papers. Yes. Oh yes, it does mean Beweise. Nothing but that. But there is a difference between certain types of Beweise, types of evidence, and one of it is Indizienbeweis, which is prima facie evidence. Okay, so first you have the prosecutor who gets material from the police, and then you have the magistrate who decides about the committal, and then the case goes, in England at least, goes to the Crown Court, right? Which, interestingly enough, exists in about 70 centres, but is still always referred to as the one Crown Court. And remember, it is a serious criminal case, so the trial is before a judge and jury. Die Verhandlung oder der Prozess findet daher wegen der Schwere des Verbrechens vor einem Richter und Geschworenen statt, das heißt vor einem Geschworenengericht. The same thing would exist in Austria. If it's a serious case, you will also have a jury. And you will most likely have not just one judge, but a panel of judges. Usually it's 2 judges. Sometimes in Austria, when the criminal case is, well, not so serious, but serious enough, let's define it like that, you might have a professional judge and 2 so-called lay assessors. The lay assessors translate as Schöffen. Okay? And then in Austria, this is what we call a Schöffengericht. Also das Schöffengericht liegt eine Stufe unter dem Geschworenengericht. In former times, a Schöffengericht used to be composed of 2 professional judges and 2 lay assessors, but in the course of the most recent reforms of the judicial system, the number of professional judges was reduced. Right. And in case of what you would call a misdemeanor, for example, also im Fall eines Vergehens, das heißt eines weniger gravierenden strafrechtlichen Verstoßes, kommt der Fall vor einen Einzelrichter. In that case, a judge sitting alone will actually be in charge of the trial. So the important thing here is that the judge seeks to ensure clarity and fairness, consider and decide legal issues, whether a piece of evidence is admissible and should be put before the jury, and instruct the jury as to the correct view of the law relevant to the case. So the judge is in charge of the legal side, the jury decides the facts, whose story is more believable, and then applies the law to those facts. So eventually it's the jury that reaches the verdict on the guilt or innocence of the defendant. And the prosecution has the burden of proof. Das heißt, das Urteil im Sinne von schuldig oder nicht schuldig, guilty or innocent, the the verdict on the guilt or innocence is reached by the jury. And what is the German equivalent to the burden of proof? Does anybody know? Die Beweislast. Reach a verdict, yes. Like erreichen, yes. Zu einem Schuldspruch kommen oder beziehungsweise zu einem Urteil kommen. I would not use the word erreichen in the legal context. It's, in colloquial language, of course, it's the same word, but I would say zu einem Urteil kommen. Yeah, the Beweislast, sometimes also referred to as the onus of proof, onus being the Latin word, O-N-U-S, onus. And there is another Latin phrase that also applies here, which is in dubio pro reo, im Zweifelsfall für den Angeklagten oder die Angeklagte. Or in English you could rephrase that as the defendant or the accused is innocent until proven guilty. Okay, that would be the comparable legal phrase. So it's not the defendant that has to prove his or her innocence, it's the prosecutor who has to prove the defendant's guilt. And this must be proven beyond reasonable doubt. So as long as there is reasonable doubt, solange berechtigter Zweifel besteht, the principle that I just mentioned in dubio pro reo will apply. Okay, we started from the top here with the criminal cases, in fact, because we started with the serious criminal cases that go to the Crown Court, whereas in less serious criminal cases, the case is sent for summary trial in one of over 400 magistrates' courts. Now, magistrates' courts very roughly would be erstinstanzliche Gerichte. That would be the comparative or the equivalent level in Austria and Germany. The names might differ. In Germany you would find die Amtsgericht. Also da gibt es zum Beispiel einen Stufenbau, der bei den Amtsgerichten beginnt. Oder vielleicht sogar noch drunter, entschuldigen Sie, bei den Bezirksgerichten eigentlich. In the district courts and for even very, very small misdemeanors. And then it would go up to the first instance court, that is the Amtsgericht, and the equivalent being das Landesgericht, the regional court in Austria. Summary trial would mean that it is a short-track proceeding, sozusagen ein Schnellverfahren, ohne ein formelles Vorverfahren und ohne ohne ein langes Vorverfahren, genau genommen, und ohne Geschworene. And this is where an element that is very similar to the Austrian Schöffensystem comes in. The trial is before a bench of magistrates. In most cases, there are 3 magistrates who are lay persons. In other words, they're not professional judges, nor are they lawyers, but like the jury, persons from the local community. So the bench of magistrates would basically be similar to what I called a panel of judges earlier. Das heißt eine Art Senat von Richtern mit Laienrichtern und Berufsrichtern. Lay judges and professional judges. And the stipendiary magistrates are actually, or stipendiary magistrates are actually very specific to England. Because to us it seems strange to have a magistrate who is not paid and who is not a qualified lawyer. Well, of course, the lay judges are not paid. They just get expenses, and they are not qualified lawyers. But they're not supposed to be qualified lawyers, because they should bring the common sense approach into the proceedings. Okay. And what you can see here, the court structure with the various stages of appeal in very simple terms, very nicely. The court structure is what we would call Instanzenzug der Gerichte in German. Okay? So the various stages of the judicial system, the Instanzenzug. If we look at civil cases in England, words and the system are slightly different, because here you don't have a public prosecutor any longer, of course. Needless to say, because this is between private parties. This is not between the state and an alleged criminal. This is between private parties who have grievances against each other. Im Zivilrecht, im Zivilverfahren gelten andere Bezeichnungen. We had the defendant first, in the sense of Beschuldigter, or the accused, der Angeklagte. Here we have the plaintiff and the defendant. So the litigation is between those two, and the plaintiff has to take the first step. Pardon? Plaintiff ist der Kläger, die klagende Partei oder Kläger. So it's not Ankläger, öffentlicher Ankläger, Staatsanwalt in that sense, but Kläger. In English, plaintiff, you can see it up there. It might be hard to see, but it's in the first line. In civil cases, the litigation is commenced by the plaintiff. Okay? It could be a private person, an individual, a company, or a public authority, as long as it's a civil case. Sometimes, depending on the background, the defendant, die beklagte Partei oder der Beklagte, die Beklagte, could also be called respondent. Usually this is the case when it's an arbitration matter. Das ist meistens dann der Fall, wenn es eine Schiedssache ist und keine Sache, die vor einem normalen staatlichen Gericht ausgehandelt wird. Also die Bezeichnungen vor Schiedsgerichten sind anders. The difference between regular civil cases and arbitration are such that arbitration is something that the parties, when they sign a contract with each other, agree upon. They agree that they would not go to the civil courts. They agree that they will have arbitration in case of any dispute. Das ist also eine freiwillige Form der Gerichtsbarkeit, derer sich Vertragsparteien zum Beispiel unterwerfen und ausmachen, sollten wir eine Streitigkeit im Rahmen eines Vertrages haben, gehen wir nicht zu Gericht, sondern wir gehen vor ein Schiedsgericht. Das ist ein Parallelsystem, ein zweites System der freiwilligen Gerichtsbarkeit. But let's stay with the civil cases, with the state courts in charge of civil cases. So the plaintiff and the defendant go to court. The plaintiff must try to prove that the defendant is liable for something. Die klagende Partei muss also beweisen, dass die beklagte Partei für irgendetwas haftet oder verantwortlich ist. That's the word liability. Liable for. And there's usually a claim. Es gibt meistens eine Forderung, aufgrund derer eine solche Zivilklage angestrengt wird. So it's basically a claim that arises from a contract, or it might be based on a tort, which is a civil wrong. Also es kann eine Forderung aus einem Vertrag sein oder eine Forderung aus einem Delikt, tort, that would be the word tort in German. Das heißt eine zivilrechtliche Verfehlung, wie zum Beispiel ein Unfall. Tort, as up there. Oh, you can't read it, sorry. The problem of the lighting in here is that tort is T-O-R-T, okay? Thanks for pointing this out to me. It's really fairly difficult. I can understand that because I can't really switch off the front light. I wish I could. Can I? Can you try this? No, it just gets worse. Because if I switch off the light here, you'll be sitting in utter darkness. I mean, it might be nice for you to see the screen, but then you can't write down anything. So, I think we have to make do with this, and you will have to read it up on your own by following the link. Okay, civil wrongs such as the causing of a road accident through negligence or damaging a person's reputation through defamation or affecting the enjoyment of property through causing a nuisance. Also die fahrlässige Verursachung eines Verkehrsunfalls by negligence, fahrlässig. As opposed to, in German, vorsätzlich, with intent. Oder Rufschädigung durch Verleumdung oder Beeinträchtigung des Genusses des eigenen Eigentums, zum Beispiel durch Verschmutzung, yeah, and land disputes also falls under this heading, and the choice of court, and this is basically the same in the systems, in the court systems everywhere. The choice of court depends on the value of the claim. Das zuständige Gericht oder die Zuständigkeit des Gerichtes richtet sich nach dem Streitwert, dem Wert der Forderung. Sometimes you refer to it as value in dispute, Streitwert. Sometimes it's value of the claim, also Wert der Forderung. And there is a certain amount. If it's worth less than that, you go to a district court, to a lower court. And if it's worth more than that, you go to a higher court. In the UK, you start in a county court, which is roughly the equivalent of a Bezirksgericht in Austria. Though in Austria you would call it a district court rather than a county court because we don't have any counties in Austria. In Austria, the names of those administrative units are different. We have Bezirke and we have Länder, and for this reason we don't have any county courts. Here, obviously, the limit is £3,000, beyond which you have a small claims procedure with a quick hearing. And then the higher courts, which could be circuit judges or county court judges. And the interesting thing about the civil law system is, the civil cases is that you call the proceedings actions. You file an action. Man strengt einen Prozess an, man klagt jemanden. Sometimes you also call this to sue somebody, sue in a court, as in the name sue, S-U-E. And you might also refer to it as a lawsuit, ein Zivilprozess. You might also say you bring an action. This phrase also exists für klagen, für jemanden klagen. Or you commence an action. Yeah, many of these actions are for the recovery of debts based on contracts. Also in sehr vielen Fällen geht es um die Betreibung von Schulden. And one thing that will strike you is also the difference in usage between the German, Austrian and Swiss civil system. In the civil courts you will find entirely different language. So you might just want to read up on that a bit too. Let me just see. I just put in Beitreibung von Schulden, whereas earlier I said Betreibung von Schulden. So what's the difference? It's just Austrian and German legal language. Betreibung von Schulden is very much the Austrian usage, whereas Beitreibung von Schulden is the German system. Okay? So again, I'm not trying to teach you an all-encompassing view of what is said in Germany for each word, what is said in Switzerland, and what is said in Austria. Of course, my focus will always be on Austria, since we are here in Austria. I work for Austrian courts all the time. But I'm trying to point out that you have to be very careful not to, even though it's all within the same language, German, there are huge differences in some instances, in some cases. Okay? The English word for Betreibung or Beitreibung von Schulden, we had that, it was recovery of debts. Recovery of debts. Recovery as in sich erholen, but in that case it's getting it back, okay? Sometimes you might also refer to it as the enforcement of a debt or the collection of a debt. And many actions relate to land, such as actions for the repossession of land or houses after non-payment of a mortgage or rent. Sometimes it might be matrimonial proceedings. Manchmal können es auch eherechtliche Verfahren sein, matrimonial proceedings. Okay, now, if it's a claim that involves a higher amount of money, you go to the High Court. Again, with a centre in London, or actually located in London, but with centres throughout the country. Just like with the Crown Court, where you have the Crown Court, the actual Crown Court in London, and the various centres throughout the country. And actually, you start the action by submitting a writ and a statement of claim. In Austria, the proceeding is not exactly the same. There, you usually submit just a statement of claim. Statement of claim translating as Klage, die Klage oder Klageschrift. Writ is one of those English words that has a couple of meanings. So it could be any of those. And mind you, the writ is in England is something that comes from the court, whereas the statement of claim comes from your lawyer or yourself if you don't have a lawyer. It's usually wise in a civil case to have a lawyer who will write a good statement of claim, not just saying Mr. X owes me this amount of money, but who will also base this on the contract, the evidence, and also on various provisions of law. Excuse me. Okay. So, there's writ that comes from the court, die gerichtliche Anweisung, plus the statement of claim. And then it is usually, the case will usually be heard. If the defendant does not respond to the writ right away and pay the debt, for example. Okay, the various divisions of the High Court are divisions that you will probably also find in Austrian courts, such as a family division. In Austria, you would call it das Familiengericht. Which is in charge of divorce, child welfare, and wills. It might be custody matters, also Sorgerechtsfälle. It might be divorce proceedings, divorce by mutual agreement, or divorce that involves litigation over who is at fault and who owes how much in alimony or maintenance payments. Also bei Scheidungsverfahren gibt es dann die Möglichkeit der einvernehmlichen Scheidung by mutual agreement oder der strittigen Scheidung, wo erst eine Verfehlung festgestellt werden muss und wo dann auch festgelegt wird, wer wie viel an Alimenten oder an Unterhalt schuldet etc. Und all das würde in England in der Family Division, also in der Familienrechtsabteilung, verhandelt werden. In Österreich haben diese Funktionen die Bezirksgerichte. Da gibt es dann auch Richter, die spezialisiert sind auf Familienrechtsangelegenheiten. Dann gibt es Richter, die spezialisiert sind auf Verlassenschaften, which would be probate proceedings. You can find it here, probate, P-R-O-B-A-T-E. That's the administration of wills. You would not find anything equivalent to a chancery division that would be called thus. The chancery division is simply an untranslatable institution in the British courts. Again, depending on the amount in dispute, it would be a matter for a district court or for a regional court. Also für ein Bezirksgericht oder Landesgericht in Österreich. As you can see, the disputes here would be about wills, if they are not uncontested, settlements and trusts, bankruptcy, land law, intellectual property, and corporate laws. Bankruptcy petitions, also sogenannte Konkursanträge, würden hier verhandelt werden. And then in the Chancery Division there is this subdivision called the Companies Court, which would be the equivalent of a commercial court in Austria. In Österreich wäre das das Handelsgericht. And in Austria it translates as commercial court rather than companies court. And then the Queen's Bench has a commercial court. So this subdivision, the Companies Court, would not exist in Austria. Again, Queen's Bench does not really translate into anything. It would have to be, in a translation, have to be explained by what it is. Okay? So in a translation, or if you have to explain the system in a text to anybody, if you have to write about it, you would probably have a nice little footnote here explaining, because you cannot translate. Neither Chancery Division nor Queen's Bench Division can be translated. Okay? And as you can see, it also has a Crown Office list with cases against public authorities and an Admiralty Court. In Austria, if you sue the Republic of Austria, you don't have to go to any special court because there is no special division for that. You just go to a regular civil court, and there is no Admiralty Court in Austria because we don't have a sea. As a landlocked country, we would not have any cases that concern shipping by sea. Okay? So this was a brief overview of the criminal and civil law system and the court system in the UK. I would urge you to continue reading this source and yeah, keep looking at it whenever you can. Pardon? Oh, the link. I will give it to you once again. So obviously, the link that you find in the paper, www.leeds.ac.uk, which is for the University of Leeds, still exists. Of course, the university hasn't been closed down. Then it's /law/Hamlyn, spelled HAMLYN, sorry. And then it's obviously /whatever, right? So you might, we might just briefly give it a try what happens if we skip the last part. Okay, well, this gives you the start page. If you just enter Hamlyn and /, it gives you the start page of the Hamlyn Trust. And you get all the UK law online sources that were generated for legal students. And you might want to continue referring to that to learn more about the system. So much for that. I'll see you again next week. And I hope you found it interesting. If you have any questions, and if you need to be logged on to Fronter, if I don't have your Matrikelnummer, if you don't have your registration number, I can't actually enter you. So if you haven't signed up for this course, if you haven't registered, and if you haven't given me your Matrikelnummer, I cannot register you. Right? So if you still need access to Fronter, send me an email. So thank you very much.
Und ich habe ja noch nicht eine Note bekommen.
Ich habe die Noten noch nicht eingetragen. Ich mache das jetzt diese Woche. Es tut mir leid, ich bin ein bisschen in Verzug mit all meinen Sachen.
Sicher sein, dass es kein Problem gibt.
Nein, es gibt kein Problem. Ich habe die Noten immer noch nicht eingetragen. Ich wollte es am Wochenende machen, aber dann habe ich es nicht geschafft.
Okay, dann
alles klar. Aber Sie können beruhigt sein, es ist niemand durchgefallen. Das heißt, also...
Wirklich?
Ja. Also Sie sind sicherlich durch. Ich kann Ihnen die Note jetzt nicht auswendig sagen, aber Sie sind sicherlich durch.
Ich möchte Sie fragen, kann ich schon heute den Test abholen?
Sie können ihn leider nicht abholen, weil ich die Noten noch nicht eingetragen habe. Die Tests liegen noch zu Hause. Aber gerne nächste Woche. Ja? Gut.